The Republic Act Number 10175, known as the Cybercrime Prevention Act of 2012, is a consolidation of Senate Bill Number 2796, proposed by former Senator Edgardo Angara, and House Bill Number 5808, authored by Susan Yap Sulit of the 2nd District of Tarlac. This was finally passed by the Senate and the House of Representatives on June 5 and June 4, 2012, respectively. It was signed into law by the former President Benigno Aquino III on September 12, 2012. The objectives of this act are to protect the confidentiality, integrity, and availability of information and data online, and to penalize the acts of misuse, abuse, and illegal access to information and communications technology. The cybercrime offenses stated in this bill are cybersquatting, cybersex, child pornography, identity theft, illegal access to data, and libel. Any person found guilty of such punishable acts must be punished for imprisonment and/or a fine of 200,000 to 10 million pesos depending on the offense made. The National Bureau of Investigation and the Philippine National Police are responsible for the efficient and effective law enforcement of the provisions of this act. An interagency body to be known as the Cybercrime Investigation and Coordinating Center shall be headed by the Executive Director of the Information and Communications Technology Office under the Department of Science and Technology as chairperson, with the Director of the NBI as vice chairperson, the Chief of the PNP, head of the DOJ Office of Cybercrime, and one representative from the private sector and academe as members. The CICC shall be manned by a secretariat of selected existing personnel and representatives from the different participating agencies.
However, the newly passed cybercrime law on September 2012 has received plenty of criticisms and was opposed by various groups and individuals for the constitutionality of some of its provisions. And for this reason, 6 days after the effectivity of the law, the Supreme Court issued a temporary restraining order. On February 2014, the Supreme Court claimed that the online libel provision stated in the Act is constitutional. However, the High Court clarified that only the original authors of the libelous materials are covered by the law, and not those who simply received or reacted to it. As stated by the Supreme Court, the following have been struck down for being unconstitutional. These includes With regards to the online libel provision on the Cybercrime Prevention Act, I strongly believe that having a freedom of speech is very important. And since we are living in a democratic country, everyone has the right to speak and to be heard. May the government continue to enhance the laws that will protect the citizens while balancing its state duties.